Hi, everyone. Welcome to Hashed Open Dialogue for Law. I'm Medha Srivastava, General Counsel of Hashed, and today we will be speaking with Jason Gottlieb. Jason is the chair of Morrison Cohen Digital Assets Department and White Collar and Regulatory Enforcement Practice Group. He specializes in cryptocurrency and blockchain, securities, commodities, future and derivatives, and structured finance. Jason, thank you very much for agreeing to this Q&A session with HODL. We believe that your insights and practical experience will greatly benefit our audience, so we really appreciate you taking the time out for this.
Thanks, Medha. It's great to be back with you.
So, Jason, I'm going to kickstart this with something I believe that everyone over the world in the crypto industry will want to hear your views on. What do you think are the 5 most important developments in crypto law and regulations in the US in the last 6 months?
Sure, it's hard to narrow down to just 5, so I may group them a little bit. But first, let's talk about the SEC litigation decisions, particularly the massive decisions in Ripple, but also in the SEC v. LBRY, LBRY, the SEC v. LBRY case from the District of New Hampshire, and what happens next out of those 2 decisions. So we'll talk about that today. 2 is the new SEC litigation that we're seeing. So Ripple and LBRY are decisions on litigation that was previously filed, but in the last 6 months, we've seen new SEC litigation, particularly against exchanges, Coinbase, Binance, Bittrex, and Bioxy, essentially trying to forget the retail issue of going after each token individually. Now they're moving to wholesale. Let's attack the intermediaries, these exchanges, and saying you guys were acting as unregistered securities exchanges, unregistered securities brokers, dealers, unregistered clearing agents, and you're not allowed to do that in our system. That's the SEC's view, and that's what they're taking to litigation. That is going to be complicated by the Ripple decision in ways we can discuss. Number 3 is the new CFTC litigation against the Oki DAO. Last year, the CFTC settled with the developers of the predecessor to Oki DAO, B0X, and in full disclosure, I represented the developers in that settlement. The CFTC continued to take on the DAO that had been released to the community and ended up getting a default judgment because nobody from the DAO showed up to fight the CFTC. So how that default judgment plays out, or whether it teaches us any rules of the road from the CFTC's point of view, is going to be an interesting thing to look out for. The 4th thing are the new legislative initiatives. We've talked about litigation so far, but we've also got legislation on the horizon, we all hope. There are new bills coming out from the House Financial Services Committee and the House Agriculture Committee. And in case you're wondering why agriculture, it's because agriculture has jurisdiction over the CFTC, so they get involved in these sorts of things. We also have a new Senate bill that has a prominent bipartisan support, as well as some other bills floating around in the background that may get pulled apart and put into these other bills, or maybe getting ignored. But right now we're in a giant sausage making process, and we'll see what comes out of that, if anything, over the next few months. And finally, the 5th thing, since you asked for the 5 most important developments in crypto, is the new rulemaking initiative. The SEC has proposed an amendment to Exchange Act Rule 3B16, which essentially talks about what it means to be an exchange and what exchanges have to do. Originally, the SEC proposed an amendment, and it didn't mention crypto or DeFi, decentralized finance, at all. But the DeFi community quickly realized that it would drastically affect how DeFi works in the United States by essentially requiring DeFi protocols to register. As is appropriate under the Administrative Procedure Act, there was a notice and comment period, and all of DeFi came into that first iteration and said, hey, wait a minute, you're regulating DeFi without even mentioning the words DeFi. The SEC reopened the rulemaking period and said, you're right. So now we're going to explicitly mention DeFi and talk about how this rule impacts DeFi. They reopened the notice and comment period, and there have been a slew of comment letters basically explaining how this rule is pretty terrible and, if passed in its current form, would greatly hinder the development of decentralized finance in the United States by providing that DeFi protocols have to go through a fairly onerous registration regime even when there's no one around to actually register it. So we're all watching that new rulemaking initiative that should come back around. The next public meeting on it is scheduled for October. So that's the top 5, but there's a lot there to unpack.
No, I think that sets the tone for the questions that we had in mind for you. So I'm going to start with the first one that you spoke about, which was on the recent Ripple order and the prior orders that have come through in SEC's enforcement actions against specific companies. Now, in the Ripple order, I think our audience would be interested to understand what your top takeaways from this order would be. And secondly, what do you think would be the immediate and long-term implications of their transaction-specific approach adopted by Judge Torres? And would this, in your view, impact the approach that SEC has been taking towards the industry through their regulation by enforcement?
Well, I think broadly speaking, Judge Torres got things right. And I think that the important takeaway from this, there are a few important takeaways. So first, she found that the institutional sales of XRP from the outset were a securities offering. And frankly, there's no surprise to that, right? I mean, people were investing money in Ripple, the company, hoping that Ripple was going to make their token price go up. That seems like it checks off all the factors of the Howey test, which in the United States is the test we use to determine whether there is an investment contract, aka a security that needs to be registered or qualify for an exemption. Judge Torres found that the original institutional sales were investment contracts that weren't registered and didn't qualify for exemptions because they were kind of sold piecemeal without bothering to qualify for the exemptions. So those offerings, those sales, were a securities offering. But importantly, Judge Torres explicitly held that the XRP token in and of itself is not a security. It's a token, it's software. And frankly, this is also no surprise either, given A, that it's just the right answer, and B, there were a slew of amicus briefs from all across the industry, including, one that I was honored to be able to submit on behalf of the Blockchain Association, telling the judge that tokens themselves are not securities. They can be sold as part of a securities transaction, as was the case in the institutional sales, but can also stand alone. And just because you're selling a token doesn't make it a security. Now, so it's no surprise that she agreed with that position, but the SEC was taking a different position. The SEC's view, whether they would cast it this way or not, is an embodiment theory, that the token embodies the securityness of the original sale, and that securityness travels with the token wherever it goes. Judge Torres was very plain in rejecting that theory. She said that that's not the case. And the places where that became the most plain was when she said that programmatic sales and certain other sales were not securities transactions. Now, programmatic sales, in Judge Torres' opinion, was a defined term that came from the parties' papers. But essentially what it meant to her was sales going through exchanges or intermediaries where the person purchasing the token had no knowledge or information about who was on the other side of that transaction. And even if Ripple was the end seller, they had no knowledge of the person on the other side of the transaction either. So because there was no knowledge of where your money was going from the investor's point of view, you couldn't possibly be making an investment into Ripple. A lot of folks said, well, these can't be investment contracts because there's no contract. There's no privity of contract between the end buyer and Ripple. Judge Torres seemed to wave away the idea that there couldn't be a contract, but rather that there wasn't an investment to satisfy the investment contract test. So the programmatic sales were not securities offerings. He also noted that certain other sales, including distributions to employees in exchange for their labor, for their work, were also not securities transactions. Finally, Judge Torres explicitly punted on the notion of secondary markets. There's a footnote where she says, I'm not addressing secondary markets. And secondary market transactions, you would have to examine all of the facts and circumstances of each transaction to understand whether that is a securities offering. That, too, is the right approach. because the Howey test and the test for whether something's an investment contract, as you said, is a transaction-specific test. You can't say that because someone issued a token in a security originally, that it remains a security for all time. You have to examine each and every transaction. And that makes the SEC's job much, much harder, because theoretically, they could look at any secondary sale and say, well, all the facts and circumstances around this particular sale make it a security. But they actually have to do the factual development for each individual sale, which is, a tough road for them to go. It also says that even though Judge Torres explicitly said she's not making any finding on secondary markets, the language of her programmatic sales reasoning strongly suggests, in fact, almost inexorably suggests, that any secondary market transactions in crypto would not be securities offerings. Because whether you are purchasing on Coinbase or Binance, or whether you're purchasing a token from Aave or Compound or Maker, you don't know who's on the other side of that. In fact, in the latter cases, there literally is no one on the other side of it. It's a smart contract. So the language of a programmatic sales reasoning can easily be applied to all these secondary market transactions. And the inexorable conclusion is that those as well would not be securities transactions, assuming that Judge Torres's opinion were followed generally and remained the law.
Right. That's really interesting, because I think, you would know, you would have mentioned the LBRY case also. The judge there took a distinctly different view. In the LBRY order, they said that even though some of the tokens may have some utility, that does not take away that the others were securities offering, and ended up calling LBC itself as a security. Now, how do you think the Ripple order would impact other crypto tokens that have been determined securities by SEC, whether through notices or through court processes? Even if it has been a settlement that has been agreed with the parties, how does this Ripple order impact those tokens?
The answer is messy, and that's because U.S. common law is messy. And let's focus on this point just for a moment. Mm-hmm. In several ways, the Ripple decision breaks new ground. We've never really had a decision before talking about programmatic sales, or even that has implications for secondary market sales. The previous decisions we've had on whether tokens are securities, and I'm not talking about settlements where parties generally are neither admitting or denying that their tokens are securities. That's just the SEC's view of the world. But we've had several court decisions. We have the ABT coin, ATB coin v. Balestra. We have Kick. We have Telegram, and then we have LBRY before Ripple. And in those cases, the judges were pretty general in saying, yeah, I think this token is a security. And that's not quite what they said, but that was some of the implications, sort of where they were leaning, or at least in the case of Telegram, the judge said, look, there was a securities offering, there were later tokens issued. It's all just one big securities transaction. Okay, fine. But Ripple stands as a counterpoint to these cases, and particularly to LBRY, in drawing some lines about where transactions in the tokens might not be securities. Now, notably, there's nothing in there about utility, right? I've counseled, hundreds of clients over the last 5 years who said, but my token's a utility token. And I say to all of them, that's nice. The SEC is absolutely allergic to the phrase utility token. As soon as you say utility token, the SEC says, a security, got it. So just because a token has some utility does not mean it also can't be sold as part of an investment contract, right? Like the oranges and Howey, we've seen whiskey and beavers and all sorts of other things be bound up into investment contracts. Clearly, the oranges are useful. They have utility in of themselves. The whiskey is definitely useful. I assume that beavers are useful for building dams or something, but these can all be sold as part of securities transactions. So utility doesn't get you out of it. But what the Ripple decision does is perhaps serve as a counterweight to LBRY or Cabin's LBRY, and says, well, that's nice for the initial transactions, but we're talking about other kinds of transactions here, transactions through other counterparties. Now, that brings me back to the messiness. I have to say, for all the listeners out there who are thinking, great, we've got the Ripple decision. We can all go out and do exactly what she said. Let me throw some cold water on this here. This is one district judge in one district court in the United States. And this, the decision is subject to appeal. It's subject to collateral attack by the SEC and other jurisdictions. It's subject to other judges disagreeing with it. So even since that decision, we've seen in the Terraform Labs case, Terraform Labs, who was being sued by the SEC, put in a notice of supplemental authority saying, hey, we have this motion to dismiss pending. And hey, Judge Torres, your colleague in the same district, the Southern District of New York, found that these kinds of programmatic sales are not securities transactions. Therefore, the sales that you're talking about in our case are also not securities transactions. The SEC responded to that by filing their own supplemental statement saying that they thought that the Ripple case was wrongly decided and that they are planning on appealing it or ignoring it or something. So, it's kind of nice when you can walk into a court and say, I know that some judge has decided something and that's currently the law, but we just think it's wrong, so we're not going to follow it. But B, I'll tell you, I don't get that luxury when I walk into court and say, yeah, sure, some other judges decided what the law was, but they're wrong, so you should listen to me instead. Usually that doesn't get you very far. But B, it shows you that the SEC is planning on fighting this, perhaps on an appeal, either interlocutory, before a final judgment or after a final judgment. And the SEC is also going to fight this in other district court cases, in the Terraform Labs case, even in the Southern District, and they've got some other cases pending in other jurisdictions as well. The Coinbase and Binance cases are in the Southern District of New York, in that same district, but Bittrex is in the Western District of Washington. The Bioxy case is in the Northern District of Illinois. And I would be fairly sure that those exchanges are going to cite to the Ripple decision, and I'd be fairly sure that the SEC is going to argue there that the Ripple decision was wrong and that those judges should ignore it. So we don't have the last word on this from the U.S. court system, and it's going to take a few years to sort out whether the Ripple view of the world is the right way to think about things, or whether it will prove to be an outlier in time.
Thank you. I think let's also touch upon a little bit of the secondary market offerings that you have discussed. What do you think would be, of course, we are expecting, I think almost industry-wide, we're expecting Coinbase and other exchanges who have been sued by SEC to use the Ripple order. And there's been a lot of talk about how the Ripple order completely decimates the case of the SEC against Coinbase and exchanges. What are your thoughts on that argument?
Well, I think that, we've seen Coinbase making that argument publicly already, and they're right. If you follow the logic of Judge Torres's decision in Ripple and say that programmatic sales, or sales where the end buyers did not know whether they were investing in a company or whom they were giving their money to, if you follow that logic, then every single transaction on Coinbase or Binance, with some perhaps rare exceptions of initial direct offerings where everyone knows that the money is going directly to the company, but that's going to be a tiny minority of any of the sales on these platforms. Any of the other transactions would not be securities transactions. So if I go to my Coinbase account now and I purchase, XRP or anything else, I don't actually know that I'm investing in the company. I'm just buying some of the token, and these would be considered non-securities transactions. So the Ripple decision underlines and emphasizes what Ripple's GC Paul Grewal has been saying, publicly, loudly, repeatedly, and in my view correctly for several years now, which is simply that Coinbase does not transact in securities.
And moving on to the institutional sales part of it, how do you think token launches, how do you see token launches being structured today? Because that part of the Ripple's order was a bit of a shock to the industry, as much as institutional sales were held to be in investment contracts. Do you think that this order is going to impact SAFTs that are fairly common in this industry for token funding? And is there any way in which these SAFTs can pass can be held not to be an investment contract in light of the Ripple order?
So I think that first of all, I'm focused principally on U.S. law. I'm just a U.S. lawyer. I'm not qualified anywhere else, and frankly, the U.S. law is complicated enough for us to follow. I think that it's important to understand that at least in the United States, the SAFT model basically died with the Kick and then the Telegram decisions. In the Telegram decision in particular, Judge Castell looked at the initial SAFTs, which were conceitedly securities offerings, right? They were raising money for the common enterprise of the company, and people were hoping to profit from those investments. Everyone conceded that the SAFTs were securities offerings, and they were concomitantly done under one of the exemptions, under Reg D, and we can talk a little bit more about that in a second. The question was, though, after that, once there was a distribution to the general public of these tokens under the SAFT, did that qualify as a securities transaction? And in Telegram, Judge Castell said yes. The securities laws talk about a transaction or scheme, and scheme here is used not in a pejorative sense, just sort of a pattern of behavior. So you're not just focused on one moment at a time. And he kind of drew a big circle around the SAFTs and the token issuances and said, this is all one big securities offering scheme. Again, not in a pejorative sense. And for that reason, he said this was a violation of the securities laws. With that, I think at least in the United States, people who hadn't already moved away from the SAFT model out of the uncertainty of this decision really moved away from it. So we don't see traditional SAFTs in the United States very much anymore. What we're seeing is a few different kinds of variations. One, people are still selling safe notes, a simple agreement for future equity, or just straight equity offerings, sometimes with token warrants on the side, but the token warrants are distinctly different from the initial investment. They have to be a different and differentiated offering. When people are offering equity or even tokens, they can do so in compliance with securities laws. You can offer tokens under Reg D or Reg S as if they were securities under these valid exemptions. So Reg S is mostly for US companies offering to non-US people. And we have different rules for that because we figure, well, foreign folks will have their own securities laws to protect them. So we have some requirements, but it's a little bit easier to do that. Reg D is for so-called accredited investors. And there's some footnotes. You can offer up to a certain number of unaccredited investors, et cetera, but most people use it just for accredited investors. So, VCs, people with high net worth, because our securities laws assume that those folks can take care of themselves. They don't need the full panoply of disclosures. So you can offer it a little bit more easily. So I think most people who are offering still in the United States are offering as if they are securities and they are complying with the Reg D exemptions and selling only to accredited investors. This does raise some problems because Reg D, you're issuing restricted securities. So you've got some issues in the securities laws about how to unrestrict the securities later under Rule 144, or whether for some reason they become no longer securities, like there's a decentralization of the entire platform, right? If you don't want to offer restricted securities, then they have to either not be restricted or not be securities. So we've got some issues there that all of the lawyers in the field are grappling with. But I'll tell you honestly, most people are ignoring all of that because any path you choose in the United States to issue tokens is hard. It's very difficult. And until the Ripple decision perhaps opened up a crack of a door, it was practically impossible to do it right. So we've been seeing more and more people simply go offshore. If you are issuing tokens outside of the United States and only two people outside of the United States, and there's no sales in the US, there's no marketing in the US, it is entirely offshore, then it is an extraterritorial transaction that under our securities laws, particularly a Supreme Court decision called Morrison v. National Australia Bank, those transactions are outside the reach of U.S. securities laws, right? If you're selling, if you're in France and you sell a French security to a French person, then the US securities laws don't care about that. So the idea is to move extraterritorially and leave the United States, and then you escape the reach of the securities laws. I think that's terrible for US policy. It's terrible for US innovation and growth. And that's why I hope we can fix this system soon, one way or the other. But that's what we're seeing a lot of people do.
So I think on that note, I'd start my next question, which is that do you think it is advisable or commercially practical? And the other side of it is, what impact would it have on US markets for US projects or non-US projects to geofence US users whenever they're doing token launches? In the context of SEC's action against Binance for failing to geofence properly, how strongly do you feel that geofencing efforts would really pass the SEC's scrutinies?
So more and more we are seeing folks geofencing Americans and doing things entirely offshore, basically ignoring the United States altogether, bubbling the US off, which I think is sort of tragic from a US policy perspective. Like, we are losing investment dollars, we are losing technological advancement, and because this space moves so quickly, we are going to lose a tremendous amount of innovation that's going to plant itself in other countries. It's going to be terrible for our competitiveness, which is, why I'm really hoping that Congress can pass legislation to give us a path to move forward in the United States. In terms of the geofencing efforts, like how strong do you have to be? There's an open debate about this. So one thing is absolutely clear. You can't say you're geofencing and then not geofence. We've learned that even in the Plex Coin personal jurisdiction decision back in 2018. You also can't do a wink, wink, nudge, nudge, right? If you're saying we geofence Americans, but you've got your social media interns in the Discord saying, okay, everyone, just fire up those VPNs, wink, wink. That's a terrible thing. Don't do that. You have to really take efforts to geofence, and you can't, and that even means on marketing. Like, you should be marketing to Americans. If you're doing any kind of advertisement of your offering on the web, on Twitter, on Facebook, I don't know if anyone advertises on Facebook anymore. You have to make sure that you're not actually advertising to North America. You can choose advertising settings that will exclude North Americans. But then going further, there's been some hints from the CFTC lately that they don't think that geofencing is enough because of the prevalence of VPNs. And some of them have been telling me, this is not official, this is not in rules, but just kind of discussions behind the scenes, that they are thinking that people should be blocking VPNs as well. Now, I've been pushing back on that fairly hard. I did so in another case a year and a half ago, where they appeared to accept the argument because, in my view, people around the world use VPNs, particularly in countries that have more restrictive regimes. So if you are, trying to get around the Great Firewall of China, or if you are a woman in a country that does not allow women to participate in finance, and you use a VPN to make sure that you can without, going to prison for it, I think these are things that, frankly, we as Americans, as policy matters, should be welcoming and not contributing to the repressiveness of certain regimes around the world. For a while, that argument had some favor, but I think that the regulators are now coming back and pushing back a little bit more on that. Maybe they are not persuaded by the notion that there are armies of Saudi women trying to stake on DeFi platforms. I'm not sure, but where that is going to end up is uncertain. The safest thing to do for projects is to block not just the geofence, but to block VPNs as well. But there is no official rule yet saying that you have to do that. There's no guidance or decisions yet saying that you have to do that. And I think for public policy reasons, I think it's a bad idea for the regulators to require that.
Coming to your third point about CFTC being one of the 5 most important developments. Now, the CFTC angle is quite interesting because the entire concept of DAOs was established to, bring the project to a more community-driven cycle. Now, if the CFTC's interpretation and the interpretation that is being taken in US courts is also that DAOs are similar to general partnerships, that brings into question the entire governance tokens that token holders hold. And do you think that holding governance tokens is likely to make one liable as a partner in general partnerships? Is that the trend that you're seeing in the United States?
So right now, there's no trend because there's only one data point. If you ask, Jason for Jason's theory of DAOs, I would say it's absolutely insane that just holding a token could make you a general partner. So it's important to understand, one, general partnership is a state by state creation. So the US, we've got, 50 different states. They all have their own partnership laws. Many of them have a uniform partnership law, so it's largely the same, but there are some differences from state to state. Two, all of these laws are interpreted through common law. So there are a number of judicial decisions about what constitutes a partnership under these partnership statutes and what doesn't quite get you there in terms of partnership. So reading these statutes kind of fairly and broadly, it's easy to see that when you have a group of people who get together consciously for a business enterprise to share profits and losses, then there is a good possibility that it could be construed a partnership. Now, I've said those words before, and then they get taken out of context by folks who are trying to say, see, Jason said all DAOs are partnerships. That is absolutely not the case. Because in the context of a DAO, you may have some people who came together with that in mind, but you may also have some people who have no intention of participating in any kind of business enterprise. They just want to hold a token. And maybe they want to vote, maybe they don't. Maybe they're just doing it to speculate on the token, maybe they're not. Maybe they're buying the token for gas fees so that they can use it to perform some other executable activity, and maybe they're not. The other thing about partnerships is in the US, if you are in a partnership, the debts and liabilities of the partnership are borne jointly and severally by all of the partners. To those of us who are law partners, in partnerships, this is kind of a familiar theme, right? If one of my partners does some bad stuff, then all of us are going to be on the hook for it, and that's just what we accept in partnerships. But that makes no sense as you translate it to a DAO that might have hundreds, thousands, tens of thousands, hundreds of thousands of users, particularly when we don't know what the entrance criteria are. So it makes no sense to think that if I bought one comp token, held it for a few minutes, and then sold it, that I would be jointly and severally on the hook for anything that went wrong in the entirety of the compound DAO or the compound protocol, which are two separate things, for any amount of time. Like that just doesn't make a lot of sense, and it's not in comport with partnership law as we understand it. So let's think about the data points that we have. One, the CFTC sued the Oki DAO, as I mentioned, saying that the Oki DAO was violating one aspect of the commodities laws. And the CFTC's point in this suit was fairly straightforward. The Oki DAO, it felt, was violating a point in the commodities laws, in the Commodity Exchange Act, and its view was you can't violate the commodities laws if you're an Inc. You can't do it if you're an LLC. You can't do it if you're a partnership, and you can't do it if you're a DAO. We don't care what corporate form you have. You can't violate commodities laws. That's a reasonable enough position. But in suing the DAO, no one showed up. You had a number of people who filed amicus briefs saying this is ridiculous. Why are you saying that this? How can this be a DAO? How can you hold anyone accountable? But the CFTC's view was that anyone who not just held tokens, but voted their tokens had opted into the governance of this protocol and thus were members of the DAO. So that's what was before the judge. Nobody showed up from the DAO because why would they, frankly? So the judge went on to issue a default judgment. And in that default judgment, the judge actually went a step further, and I'm not sure whether the judge did this on purpose or by oversight. But the judge said in the default that anyone who held Oki tokens was a member of the Oki DAO. And that went further than even the CFTC was alleging. Now, what's going to happen with this decision, we don't know. The judge said that the OP DAO was responsible for paying $600,000 and that it had to shut down its website. The Oki DAO, to my knowledge, has neither paid the money nor shut down the website, but it's extraordinarily unclear what the CFTC can do about this. I think the smartest path for the CFTC to take would be just to declare the win and walk away, having served the entire community with its view that you can't violate the commodities laws even with the DAO. Because if it tries to enforce and fails, then the lesson it will be imparting to the community is just form a DAO, mostly be anonymous, and then there's nothing we can do to stop you. And that, I think, would be a terrible policy lesson. So I think the CFTC would be smarter to take the win and move on. We don't have other data points quite yet. There are a couple of private actions. There was one brought in the Eastern District against the Pool Together DAO, which was dismissed on for lack of federal court standing. And again, full disclosure, I was one of the defense counsel in that case. There's another case currently pending, also against the BZX DAO in the Southern District of California, where, again, sorry for continuing to say this, I'm counsel to one of the defendants in that case, with the same allegations that there is this DAO that's a partnership and therefore everyone is on the hook. Those cases are still in early stages. The Eastern District of New York case has been dismissed. The Southern District of California case is still in an early stage, although it's survived a motion to dismiss on that theory. We also have a suit in the Northern District of California, a class action suit against the Compound DAO and some others affiliated with Compound in loose ways, claiming that DAO is a partnership. And there are two cases that are brought by a patent holder in the Southern District of New York, one against the Compound Protocol and one against Maker DAO, in both cases claiming that there's a DAO that is a partnership that they are bringing a case against. So and sorry to do this, but I'm counsel in all those cases as well. So we're all watching these cases and waiting to see what kind of scope judges are going to say. There is partnership law that governs when a loose collection of people may be deemed a partnership. But does a DAO qualify? I have to say, in my view, the answer is no. But obviously, since I'm defense counsel in all of these cases, that would be my answer.
No, I think don't apologize for being defense counsel in all of these cases, because this is the reason we are doing this Q&A with you. We think that your experience in all of these cases and others are really going to provide useful insights to our audience here. So I'm glad that we are getting some real practical guidance from you here, Jason. I'm going to move on a little bit now to discussing DeFi. So we'll come back to your fourth point in your top 5 developments, which was the 2 bills, and deal with that a little later. But on the DeFi side, how do you think that the rulemaking that SEC is now trying to do is going to impact the market? There has been, and different jurisdictions have been trying to understand how to typically regulate DeFi, because unlike traditional finance, the entire purpose of DeFi is to make you do away with the intermediaries that exist in traditional finance. So the regulator's perspective is obviously that once there is some risks that exist, and therefore we need to plug in those risks wherever they are. Not quite sure how the SEC's rulemaking is going to plug in the risk, or just going to put a dampener on innovation in the US. Just your thoughts on that.
Yeah, the SEC's proposal to amend Rule 3b-16 is not designed to address the risks of DeFi in any way other than by stamping on it, by eliminating it. The rule proposal as it stands would leave no path for DeFi to exist, because it would require registration as an exchange of any DeFi protocol. And it's entirely unclear to me how a DeFi protocol, frankly, could register as an exchange, particularly those protocols that are no longer really in the hands of any one entity, but are rather dispersed to a wide variety of community members. It does not seem very likely to me that a large dispersed community can get together and decide we're going to go register this as an exchange, particularly when the requirements for registration and how they would operate are inimical to how these DeFi protocols work. There is a limit to the amount of KYC that one can do in a permissionless network. It can be sort of plugged in behind the scenes for certain issues. Like nobody wants North Korean terrorists to be using DeFi. There are ways behind the scenes of screening out sanctioned wallets, etc. But it would be impossible for these exchanges to A, do the kind of reporting that the SEC wants, B, to do the kinds of disclosures that the SEC wants in this rule, and C, to even have the wherewithal to register, to maintain that registration. So the SEC's rule proposal would really stamp it out. And there was a slew of comment letters addressed to the SEC on the last proposal. I was honored to be able to work with Polygon Labs to submit one that focused on the role of validators in DeFi networks and explain why the 3B16 amendment would, on a technological level, be impossible for validators to comply with, and thus would basically sentence DeFi to death. Now, we don't know what's going to happen with this rule. It's very possible that they look at all the comment letters and say, you know something, we've got a lot more thinking to do. We are not quite ready to grapple with DeFi yet. And as you mentioned, in other jurisdictions, that is the position that a lot of them have taken. So as we learned from our mutual friend, Peter Kirstens, back when we spoke with him last August at Korea Blockchain Week, in the MiCA regulations, the European Union decided basically to carve out DeFi from this round, because it was hard enough for them to figure out the first tranche without tackling DeFi. So Peter would joke, DeFi is left for MiCA 2, which will not involve me. That's all of your all's problem. I don't want to deal with it. So, a lot of jurisdictions are struggling with it. We've seen the US Treasury bring out a risk assessment of DeFi and trying to figure out what we're supposed to do with it. But I don't quite think that we're ready for it. Now, some of the legislation that we're dealing with does deal with DeFi networks in some ways, but I think for now, it's mostly just to give a little bit of space. So Section 309 in the draft legislation that came from the House Financial Services Committee would basically exempt validators from any kind of registration requirements, which would solve a lot of the problems that we were raising in the Polygon Labs letter. So, we're waiting to see what's going to happen both on the legislative and on the rulemaking front.
On that note, Jason, we'd like to hear your opinion on the kind of regulatory framework that could, potentially achieve the balance between what the regulators want and what the innovators in the DeFi market are trying to create.
So I think that nobody is ever going to get 100% of what they want, but we can really try to get to some sort of, a Pareto optimal place where everyone gets a vast majority of what they want with a good balance. And the balance is this: there needs to be disclosure about what the system is, how the system works, so that people can make informed decisions about whether they want to use that system or participate in that system. So people who are designing a system and releasing it could put out certain amounts of disclosures. Now, this is not an earth-shattering statement. In most of the large DeFi protocols in existence have extensive white papers and tutorials and facts that tell people all about the protocol. I mean, everything there is disclosed. And of course, on a lot of these, you can go on to Etherscan or a similar kind of service, depending on the chain. And you can see every transaction that's happened on the protocol. So you have full transparency, both of the systems, how it works, and of the transactions that are on the protocol. So that kind of disclosure is good, and I think that some sort of rule requiring those sorts of initial disclosures would be useful. After all, these protocols can be decentralized after a time, but ultimately, like, someone programmed it, someone launched it, so it's not crazy or unreasonable to require a certain amount of disclosure at the outset.
Mm.
The second thing that we may think about is security, some level of contract security, and whether that's smart contract auditing or anything else. I'm not a particularly technical person. The last time I did any coding was 25 years ago, and I was so terrible at it, they told me to stop coding things and go back to law. So I'm not going to pretend to be able to understand the ins and outs of all of the code. That said, one of the biggest risks we've seen in DeFi time and again are hacks or manipulations of the system where actors and other threat vectors are allowed to drain systems of other people's assets. And that's something that has really brought black eyes to DeFi, and I think something that we want to push very hard to build guardrails around to make it harder to do that. So one way we do that is retrospective, such as the actions against Avi Eisenberg, who manipulated the Mango Markets protocol, or Ande and Medjevic, who manipulated the indexed finance protocol. But we can also do a better job of some sort of prospective construction. And I think bringing DeFi back into a fold where they don't feel like they have to be outliers developing in secret, because otherwise the SEC is going to stomp them out. I think the way to truly protect people, truly protect consumers and users, is to bring these protocols back into the fold and require basically basic disclosures, some level of auditing or security, and that's going to solve 95% of the problems that we have. There's also problems with that relate to the tension between permissionlessness and truly bad actors. So government is never, ever, ever going to allow pure, true permissionlessness. And the reason for that is pretty plain and simple. I mean, money laundering is the blood through the veins of the criminal body, right? People are going to be selling drugs or weapons or other people, and they need to launder that money somehow. If DeFi could be used for money laundering, then that's something that governments are going to want to stamp out. Now, DeFi is a terrible way to launder money. So this is not legal advice out there to money launderers. My legal advice is, like, don't launder money and don't do crime, okay? Don't do it. But for people who are looking to launder money, DeFi is terrible. It leaves a permanent, immutable trace of the money trails. So it's not a very good system to do it anyway. That said, the anonymity, or at best pseudonymity, of the systems could potentially make it an inviting target. And we have seen some criminals, albeit of the dumber variety, try to launder money through cryptocurrency. So having ways to establish that wallets that are on a sanctions list or connected to sanctions lists are not allowed to engage with the system is something very useful to do. Now, that's being taken care of already in the private sector by and large. You have organizations like TRM and Chainalysis who are doing fantastic jobs in allowing protocols the optionality to block wallets that are connected to certain kinds of illegal activity. And I think it's very useful to incorporate that into protocols. But there are going to be certain guardrails and certain minimum thresholds that I think should be met, because otherwise the governments of the world are not going to be able to let that rest.
Now, moving on to the two bills pending before the Congress, I think the world is waiting for US to legislate on crypto law and regulation, bring about a certain amount of certainty given the huge market that United States is. So it'll be helpful if you could give our audience your insights on the two bills, what are the basic parameters that they seek to address? How do you see these bills progressing in the coming year, particularly because you are in an election year now?
Yeah, so I'll leave the nitty-gritty details of the bills to a separate session because I could spend hours on those, and it's also a moving target, right? The House Financial Services Committee and the Agriculture Committee are getting together, I think, this week for a markup of the bills to reconcile differences between those two bills, and the differences are not super extensive. I think the Ag bill really built on the HFSC bill. So hopefully they'll be able to come to some conclusion. We also have a Senate bill sponsored again by Senator Loomis, a Republican from Wyoming, and Senator Gillibrand, a Democrat from New York. So we have people working across the aisle to try to come to the best policy solution. And I really do think that this is one of those times in Congress, frankly, one of those rare times where you have people from both sides of a very heavily partisan divided aisle, the Republicans and the Democrats, are really trying to come together to get to what the best policy is. So in the conversations that I've been having with members of Congress and staffers on both sides of the aisle, what the common thread that I hear is people struggling to reconcile really differing viewpoints on legitimate issues that are really tough issues, that are tough policy issues. How do we deal with customer protection versus freedom to innovate where there is any tension between those? And how can we resolve those tensions so that we can have both? How do we protect privacy, financial privacy for people? At the same time, we are ensuring that, North Korean terrorists can't launder money through our systems, that they can't use privacy as a weapon. The policy discussions we've been having have been very interesting and very focused on that. One of the key policy decisions is if you create a system where people have an easier regime to issue crypto tokens than securities, and they can do so to raise money, well, then why would any traditional company go through the rigmarole with the SEC of, an S1 or full registration statement if they could just opt into a less disclosure crypto system and issue tokens instead of traditional securities? And that's something that the SEC is afraid of, and it's frankly a valid point. I think that there are policy ways to handle it, and I'm seeing people working very hard on the policy front to try to address all of those issues. Now, in terms of what's the promise, particularly during an upcoming election, the elections of 2024 that take place next November, that gives us a fairly limited window. We really need to make some good, solid progress over the coming months. Because I think as the calendar turns to 2024, increasingly people are going to be occupied with the election and electoral politics, and that may make it much more difficult to get anything passed through Congress. Both because during election seasons, each party tends to retreat into their camps, and it becomes more about Democrat versus Republican. But also just because people's attentions are more focused on getting out to the campaign trail than they are, sitting in the long policy sessions marking up bills. So hopefully we can get things moving very soon over the coming months. But you've got people on both sides of the aisle in House Financial Services Committee are really working very hard to move this forward. I sense that in the recent year, it's become a little bit more Republican versus Democrat, with the Republicans being pro-crypto and Democrats being anti-crypto. But that's by no means a hard and fast rule. And you have Democrats in the House Financial Services Committee, like Richie Torres from New York and Wiley Nichols from North Carolina, who are really doing great jobs in advancing smart policy that I think will be net job creating and also provide a pathway for this technology in the United States.
That's really good to hear. I think we are all waiting and watching. So let's hope that something good comes out of these two bills that are pending before the Congress. My last question for you. Any last advice for projects trying to navigate the US regulatory roadmap?
Get a lawyer. Of course, I would say that. Of course, I would say that. But I think that we are in a time of incredibly shifting sands between the legislation, the regulations, the rulemaking process, and all of the litigation going on. We are at a point now where I think, frankly, it is less certain what the next year will hold for crypto than it has been in any year since crypto came out. When I started doing this advisory work in 2016, I was telling people things are very unsure. We don't know what the rules are. We don't have clarity from the SEC, but hopefully we'll know more within a couple of years. So here we are, 7 years later. We do not have that clarity. In fact, we've got a lot more data, but it's data points all over a map. It's like somebody tried to draw a map, an arrow telling you which way to go by taking a whole handful of coins and tossing them up in the air, and then they fell all over the place. And they said, "Here's your map. Good luck." So we're all trying to navigate that map, and all watching all of these different trends. The advice I would give to entrepreneurs and innovators out there is this: don't give up, keep building, because there will be a path for smart, useful technology. If what you're building is good and useful and safe, then people are going to want to use it. Rule makers are going to want to allow it. Legislators are going to want to encourage it. So despite all the uncertainty, that's what you hire the lawyers for. Offload your worries to them. You should just keep your chins up and keep building.
That's some really good advice. Thank you so much, Jason. On behalf of the entire team at Hashed Open Dialogue for Law, we are very grateful that you were able to provide your time to us for this entire conversation. The question and answer sessions have given, I'm sure will give our audience great insights into the US crypto law. I don't think there's a roadmap, like you said, but at least it'll give them good insight into what is happening into the United States. We would like to speak to you again on this as more and more things develop. So let's hope this is the first of many Q&A sessions with you.
Well, Medha, thanks. It was a pleasure to be with you. And as I frequently jokingly tell people, I talk about this stuff pretty much 24/7. Whether anyone's around to listen to me or not. So I'm happy to speak with you about it anytime.
Thank you so much. Thank you for listening, folks.